Good morning, ladies and gentlemen. It's good to see people here on the second day of dmexco 2018. It's good to see you're awake. It's good to see you're still interested in the content that we will provide on this stage. Good morning, everybody. Wake up, yeah? You can clap your hands. Good. Well done. Well done. We're getting there. I just want to wake you up for our speakers that will be coming up next. So one question before. How was the parties last night? Good? Yes? No. Parties weren't good. So the parties were so good you couldn't even answer anymore, right? So it's a bit of a tricky one. I see some tired faces here in the audience. So we will be sure we get you awake. No worries about that. And we have a fantastic topic for the beginning, which is probably the most exciting topic at the whole dmexco this year, GDPR. GDPR is a fantastic topic, right? Yes, I know it's a bit dry, but it's one of the topics that companies are engaged in. Everybody has their challenges. We are trying to see what kind of challenges are coming up, and we want to see what is the business impact of GDPR, what are the problems that arise, but also what are solutions to handle GDPR in the future from an EU perspective as well, because we are facing a market of 450 million users. Europe is big, and all the companies obviously struggle a bit with the topic. And we've got a great panel here, which I'm going to show you now, and I'll get them up on stage for you. And the people who are coming up is, first of all, from the Commission Nationale de l'Informatique et la Liberté, Armand Eslot. Come on, make some noise for them when they're coming out. Great. They're doing well, right? I know. Next of all, we have the member of the executive board at United Internet, and he is Jan Oetjen. Morning, Jan. Just to wake you up a bit, that's good. And next of all, we've got the digital risk director at Group M, Bethan Crockett. Bethan. And then we've got a moderator. She's the Vice President, Chief Privacy Counsel at AppNexus, Julia Schulman. Good. Good morning, Julia. So, first of all, what we want to do is we want to have your activity. So you grab the remote controls under your seats, and we will be asking you one question, which is the voting tool question, and you'll see it on the screens to your right and to your left. And the question is, GDPR and ePrivacy, does the vision become reality? Number one, yes, providing transparency and control will be a success. Number two, no, both regulations are threatening businesses and confusing the users. So press now, and we'll see what's coming out. Bethan, what do you think what's going to come out? What is the audience going to say?
I'm an optimist. I'm hoping for one.
One? Julia?
I'm going with one as well.
One? If you didn't say that, I don't know.
Of course, I'll go with option one.
Option one?
I'm afraid that's going to be two, so regulation is never popular, so let's see.
So that's a very German approach. I didn't say that. Okay, can we have the results, please, on the screens, so we see what the audience is going to guess? That is close. Surprising. Well, we are in Germany, that might be the reason, but it's an international audience, you never know. Kick it off. Give them a hand again, please. Thank you.
Good morning. We have a light topic for breakfast this morning, so thanks for joining us. I'm stepping in for Townie Fian from IAB Europe, who unfortunately was unable to make it this morning, so bear with me as I work with our panelist here, as I was actually supposed to be one of the panelists. And I'm going to dive right in. I think this is obviously a topic near and dear to my heart as the Chief Privacy Counsel at a third-party advertising technology company, and deeply important to our industry and to consumers as a whole across Europe and globally. So, Armand, I'm going to start off with a question for you. User reactions since May, given the importance of this regulation to users. GDPR was intended to give users more transparency and control of their personal data. Does the CNIL see evidence that this is what is happening? Do you think consumers feel more in control? What's been consumer reaction since May as far as the CNIL can observe it?
Well, actually, we've seen lots of reactions from the users. The first reaction is that we have a huge rise in the complaints that you have received at the CNIL. Usually, we received around 1,800 complaints from the period between now and the entry into force of GDPR. And this year, we have received 3,000 complaints, which means an increase in 56% of all the complaints we've received. We've also seen a huge increase in phone calls to the CNIL. We have seen a rise of 40% of people calling to ask for advices, both from data controllers and from citizens. Mm-hmm. And we also have a huge increase on the statistic on our website. We are seeing that lots and lots of people are interested in the contents we have on the website, both from data controllers and data subjects point of view. Regarding the feeling of a user, what we perceive at the CNIL is that the user want to have more control. Right now, they have fully understood that they have more rights, that the GDPR is giving them some rights they didn't have before, and that for the rights they already had before, there are now some sanctions, some fines which are possible, which are going to change how the industry is working. And there is a huge demand from this perspective. On the concrete part, on the concrete effect of a GDPR, right now we're seeing that some lines are shifting, things are changing. It's obviously far from perfect. Companies still have a lot of work to do to put themselves into compliance, to understand what the new rights mean. That's an ongoing work, but it's going in the right direction.
Okay, it's really good to have metrics and understand, because I know all of us have been wondering, what the DPAs have been seeing. And to your point on companies really trying to work and understand their obligations and what they can and can't be doing, what could industry be doing or doing more of to help DPAs?
That's a very interesting question. I would be a bit provocative on the first part on the answer and say that what the industry should do is to really try to apply the regulation and to try putting effort into circumventing it. We've seen different reactions from the industry, from the regulator point of view. Some companies are really trying to get to comply with the regulation, trying to understand how the new rights work, trying to understand the new obligation. Some other companies that we have tried to discuss with in order to find a concrete solution to implement the obligation of GDPR are refusing to apply the regulations. As regulator, our first objective is to ensure compliance of companies and to ensure that citizens, data subjects, can exercise the right across every company. And we're trying to find out, to build some concrete solution with companies. And some companies are still refusing to adapt themselves because they think that the GDPR is in contradiction of their very business model and that they simply do not want to apply the law. So the first thing to do would be to try to really apply the law. Second point would be an example. We're quite interested by what the EAB has been doing on the consent framework. We think that from our point of view, it's of course not perfect. It's going in the right direction. And it's very interesting because it's a solution which has been built by the industry. And here we're seeing that really some lines have shifted. And we think that overall, that's a good approach. And that's what we would like to see from the industry. We are not here to sanction and fine the industry. We're here to ensure that they will get into compliance, and we're here to help them to build compliance. So the more the industry organizes and builds some new tools, some new ways to build compliance, the easier it will be for us.
Mm-hmm. That's really, really helpful. I'm going to flip the question and actually ask Jan and Bethan, what resources or tools do you feel would be most useful going forward as you continue to assimilate the implications of the GDPR and align to its requirements? Are there things that European enforcement authorities like the CNIL and potentially other industry associations could usefully provide? Jan?
Yeah, I think the key challenge that the industry is facing right now is that we have a lot of unclarity what the regulation really means. So if you look at the means of implementation company by company, just with regard to cookie tracking and so on and so forth, solutions vary from here to there, right? So and I think what would be great is a guideline from some authorities of what their interpretation of the law is, and not leave it to the economy and to the companies and then to the judges at the end of the day to find the way how to implement the GDPR. I think that's one very important thing. And the second thing I wish we'd have is somehow to have, we now have the big chance of having equal conditions for every company in Europe. So I think what's very important for the industry is that we really find an equal implementation of these rules across Europe. Because it can't be that you have, if you're in Ireland, if you're in Luxembourg, if you're in Germany, the different rules will apply depending on where the company is having its headquarters. Right?
Mm-hmm. And Bethan, anything else to add?
Very much on the same page. I think we are grateful to the data protection authorities that have allowed us as an industry to go and present the solution that's being built by the IAB and through cooperation across the industry, and ask for the feedback. Is this the right direction? Is this matching up to your interpretations of the law? Is this going to be enough consistency? Will we be able to apply this across all of our countries within the EU, and this will meet the requirements? This will allow us to be in compliance. And I think if we're coming as the industry and presenting that and saying we're doing our best, this is the direction we think we need to go, we very much then need a yes or no response to that, because a halfway answer means, do we keep going? Is there something fundamentally missing we need to change? Is there something we haven't thought about? Are you going to interpret the law 3 months from now in a way which means we'd have to come back and rework what we've already built? So I think, yes, lots of engagement and then a clear direction and decision.
Mm-hmm. And I'll add on behalf of our company, I think one thing, and Townie's not here, is I think it would be really useful for those of us in industry to continue to work with associations to educate users, work with the data protection authorities to ensure that we're all on the same page about how our technology does and doesn't function, and some of the challenges that we're facing. The other piece of that is also helping with user testing and ensuring that they actually understand and are integrating with the tools that we're trying to create here, because obviously this is all about the user at the end, and if we're not actually helping achieve the goals and requirements of the regulation, what are we actually doing? Another question for Bethan and Jan. GDPR is an opportunity. I think we hear this all the time. It constitutes a challenge to our industry, as we've all discussed, but also potentially an important opportunity. How does Group M and how does United Internet see that opportunity? Or is that opportunity obscured by the challenges, at least at this stage? Jan?
Yeah, so I think it's at least we have no choice but taking the scene that is this as an opportunity, because we can't change the rules, we can't change the law, it's there, and I think it gives two big potential opportunities. One is the equal standard for Europe. I think that's something we all were waiting for years. That it doesn't make a difference where your headquarters is located, and same rules apply basically. So I think it's now up to the authorities to really make sure that this happens. And secondly, I think the concept of giving the data authority to the user is a great concept, because it gives trust to the user. It's an opportunity to gain back trust for big companies, that you really handle their data in the way users expect to have their data to be handled. And I think those are the two big positives. And the third one is, it wakes up the industry. And I think this is something that we see as a great opportunity for Europe, that companies are really waking up now. They understand that data is the basis for all of the business models, and it's opening up the opportunities for new ways to collaborate, to find alliances, because if Europe is heading the same way as it did in the past 10 years, for the next 10 years, we'll be in deep trouble, I guess.
Mm-hmm. Bethan, anything else to add?
Yeah, I'm absolutely an optimist on this. I think it's great for the consumer, and I think there's a lot of opportunity for our industry. So the way I think about it, and we think about it at Group M as a whole, is there's a real opportunity for those providing digital content and services who have an audience that's very engaged and validated, to talk to them about what they do in terms of their advertising strategies, explain clearly what they're doing in terms of data they collect, exactly what type of data it is, let's be clear with those consumers, and then that consumer will engage, and that gives us then, from an advertising perspective, a true audience that really is receptive to the advertising. And if you do this really well, there's a competitive advantage there for businesses. So I think there's definitely a positive there to look at how we engage our consumers better. I think the cooperation point is really, really important. I've seen way more cooperation across all the industry than maybe we've seen in the past. And it allows us to look at our digital supply chains and make sure we're really clear on how they're constructed, who's involved, who we do work with. And I think the real benefit there is we remove uncertainty and we remove opportunity for risk that we've seen from fraud and malware, et cetera, that's snuck in because we haven't had that level of cooperation previously. So it gives us a different angle and result from, thinking about protecting the consumer, but we can do other things with this information for our industry. And then finally, I think as an industry, I see this as a real opportunity to explain what we do to a consumer. I think when you just say we use personal data, that sounds terrifying to a consumer, but we're not using your personal data that is really near and dear to you. We're using how you engage with online sites and services to offer you some tailored advertising, which hopefully makes the whole experience better for you. And I think it's really important that they understand that value exchange as well, because the services and the content is often free. But it's free because it's advertising supported. So let's have that real clear two-way conversation, respect all of the laws and regulations, make sure we explain how their rights can apply in that new world, in that digital advertising world.
Mm-hmm. And I completely agree with everything you both just said. Armand, this is an interesting question. Industry concern that the enforcement will be arbitrary. I hear this a lot. GDPR is arguably a regulation in the language of a directive, susceptible in many places to being understood in different ways, either because the wording is unclear, or there are gaps in guidance, or historically there is different guidance across different countries. Companies acting in good faith are reaching different interpretations, which I know a lot of us see in industry, and they're concerned that they will be punished for getting it wrong, and also that enforcement will be arbitrary. What can the CNIL say to reassure us that enforcement will be fair and that a few companies will not be singled out for punishment in order to teach the entire market how to correctly understand this regulation?
Well, my first answer would be that accountability is the key. Meaning that the GDPR has created a new concept, which is accountability in data protection. So when you're talking about companies who are acting in good faith, accountability will show that. And of course, this is something that is taken into account when data protection authorities will issue fines. The second point is that before the GDPR, there was something called the Article 29 Working Party, which was the regroupment of the European data protection authorities. Now with the GDPR, we have the EDPB, the European Data Protection Board. The EDPB is working on the fine issues, and there is also a mechanism of consistency which will allow data protection authorities to discuss among themselves before issuing a fine. This means that whenever a fine is issued for a company which is acting on a global scale, or for which the fine will be concerning global issues, there will be a discussion among data protection authorities. There is another point also, which is that the EDPB has issued over dozens of guidelines explaining how to apply the GDPR. Point by point, for example, on consent, on data breach, on DPIA, there are lots of guidelines who explain to the companies what they should do. So right now, from the enforcement point of view, our basis would be the guidelines, meaning that we have done the job of interpreting the GDPR, we have put that in the guidelines, we have agreed among ourselves at the European level to those rules, which are the strict implementation of GDPR, and now we're going to apply those rules, and so should data controllers. So my first advice would be to look at the guidelines and apply what the guideline says. Another issue, another point, we don't think that regulation is unclear. There are some new things in the GDPR, but there are also lots of stuff which already existed in the directive. The core of the GDPR is exactly the same as the core of the directive. So clearly, at the CNIL, we're going to be very strict on this core, meaning that data controllers, companies who do not comply with the core component of the GDPR who already existed in the directive, I think we won't see this as a good faith. However, on the new obligations, which are new for everyone, including the DPAs, and on which you are right, there are some questions that are still in some cases unsolved, then we will be more gentle and we will take the time to first explain to the companies how they have to do things, how to apply the GDPR, and the fines will come afterwards. Last point is that the fines, the sanctions, they're means to an end. At the CNIL, we don't think that sanctioning, fining the industry, fining the companies is an objective. The only objective is compliance. The objective is to make the industry compliant. The objective is to ensure that people's rights are protected and that they can exercise them. So whatever happens, our whole fining and enforcement strategy is aiming at putting the companies, putting the industry in compliance, not at fining them.
That's really helpful. More questions. I think we're going to jump into ePrivacy, something that I know is top of mind for a lot of us in industry as well. So, Bethan, question for you on this. How do you see the proposed ePrivacy regulation as impacting Group M's GDPR compliance and your business going forward? Does the proposal seem to put at risk some of the investments, and I know you've made a lot, into GDPR compliance? Or do you think that since we've already been living under the existing ePrivacy directive, it's not really a big deal?
So I think there's obviously a lot of uncertainty still as we follow the progress of the ePrivacy review and proposed regulation. But I think what's key to understand is because we've been working on GDPR, we've also been looking ahead, and we know that the ePrivacy is being reviewed. So we've been preparing everything we do with that in mind. We knew that law was coming as well. We know, and we've heard the guidance, it is to line up with GDPR. So we have expectations around how it will fit in. And so as we've been designing process and tools, we've kept that in mind very much. And the systems and tools are flexible, right? So we know we'll be able to adapt to the final outcomes or the proposed outcomes that are there right now around the privacy regulation. I think the big one, obviously, is it's all about the accessing and storing of information on a user's device, which we know is when you first initially would drop a cookie. That's what we're talking about here and need to be focused on as an industry. And we know from the guidance we've received so far that it's already informed consent, and we know the guidance is that the consent standard will move to that of GDPR. So it means we know we've got to think about consent in the same way we're thinking about GDPR for certain purposes now, which is that unambiguous and kind of clear consent mechanism and an affirmative action from consumers. So we know that's coming, so we're prepared and we're flexing in that direction. I think there's risk to different companies. If you've focused on legitimate interest as a legal basis right now for everything around your cookie usage, including that initial kind of connection and dropping of a cookie and then reading of a cookie, you'll have to think about how you adapt as a business. We know there's the potential that software or browser settings will have to be put forward every time they're downloaded from new or with updates, and remind consumers about potentially setting their privacy controls. So then we need to know as an industry how we'll read that signal alongside any other platforms and processes put in place, and combine the signals and make sure we're not misreading, we're interpreting correctly what a consumer has kind of indicated as their true kind of agreement or non-agreement to use of data in that way for our industry. So I think that would be a challenge for us, and we'd need to adapt. But overall, I think those that are engaged and are working on GDPR and have worked on GDPR already are ready for ePrivacy. We're already looking at it and preparing. So I think not so much a big risk to work that's already been done, but there will be potential changes to processes and systems.
Mm-hmm. Absolutely.
And maybe just let me add to that question on ePrivacy, because I think there's one dimension over what is ePrivacy going to bring for the industry, and there's a lot of debate around it, whether it's good or bad. But I'd like to add one more perspective that's more critical, that's what's really written in the law, and that's the situation where Europe is. So the next 10 years, successful or unsuccessful will be defined about the amount of data you're going to collect and the systems you have in place and the investments you're doing right now, right? So Europe desperately needs investments into data technology, into artificial intelligence, however you call it, machine learning, and it has to catch up compared to America and compared to China. So what this situation is doing right now is putting the industry into big uncertainty. So nobody can tell you when ePrivacy is going to come, what's going to be written in it, is it going to come at all? Plus, you have a quite uncertain situation right now with GDPR. So what are investors doing? Uncertainty always is poison for investments, right? So, and we need to build an infrastructure for Europe now, right now, and we're already 2 years late, to really collect data, complying with law, to really build algorithms, to analyze that data, to work with that data, to build better products, to build better advertising, et cetera, et cetera. So the industry and whole Europe just can't afford 2 more years of uncertainty. So we need clarity now. What's really going to be the situation, what's going to be the regulatory situation on data, and where we're heading, and we need this decision 6 months ago. But please, don't let the industry glide into a situation for the next election in Europe, and that's going to come in 2019, where we don't have any clarity on what regulation is going to be, because nobody can build a system, nobody's going to invest hundreds of millions, and we probably rather need billions for the technology if nobody knows what you have to adjust and what you have to adapt 2 years later on. And we invested 2 years of the most valuable resources in order to comply with GDPR. That's all fine, but we can't afford to lose another 2 years on discussing and debating about the rules. So that's my key point, take an economic perspective on it, and just Europe can't waste 2 more years on really having a rule set for Europe. The investments need to be done now.
Mm-hmm. And Armand, to this economic point, does the CNIL agree that at the very least a future ePrivacy regulation should clarify that publishers have the right to decide how they make content available to their users, as long as that processing meets the requirements of the GDPR?
Well, my response will be very clear, no. The regulation is crystal clear. In order to have a real consent under GDPR, the consent must be freely given. It means that the user should have access to the same services, whether or not he has consented. So right now, under the existing law and with the upcoming ePrivacy regulation, it is not possible to have a lawful processing of personal data if you do not obtain a freely given consent, and if you treat differently the user, whether or not he has consented. So that's basically written in the law, and if you look at the first document that has been issued by the EDPB, it's a statement on ePrivacy, also calling for a fast adoption of a new regulation, and which clearly says that consent must be freely given, and that data subject should have a real choice that they could exercise.
I think we're going to maybe let you have the last word, although one quick fire round of questions. Peer-to-peer advice. What's the advice, Beth and Jan, you'd give to all of our peers in the room here today while everyone's worrying and continuing to work toward compliance?
My quick advice was, if you don't really know what data is in your company, you can't do any compliance. So get your data maps done, data coming in, what you do with it, data going out, and who you work with. And you can't go anywhere further until you've done that.
Mm-hmm. Jan?
Invest into technology and invest into alliances.
Yep. And my advice would be work with industry. We can't do this alone. We're all so integrated and so interrelated. No one can solve this by themselves. All right, well, thank you all. Hope everyone has had a few cups of coffee while we've been talking here. Have a great day.
Thanks.
Thank you.
Thank you.